Welcome back, everybody, to our studies in land law. This lesson, we're going to move on to topic 5 of our topics in land law, covering a number of the more subsidiary elements of land law. We've spent a lot of time talking about registered title, unregistered title, the process of conveyancing. This lesson is going to start talking about the idea of co-ownership of land, the process of co-ownership, and this idea of severance. So, we're moving away from looking at the issues that I said relate to the major elements of purchasing land, whether that be registered or unregistered, for example, or when it comes to things like interest in land. And we're talking about continuing our discussion, in fact, which concerns the relationship between legal and equitable title in land. Sometimes co-ownership is merged together with the trusts of land topic. We've decided to do it slightly separately, but for the most part, we're basically following on from our previous lessons on trusts of land. And we're talking about this idea of co-ownership, the way in which co-ownership actually takes place, the methods of co-ownership, the types of co-ownership, as well as the idea of severance of co-ownership. So, what does co-ownership mean, and what do we refer to when we are talking about co-ownership in relation to this topic in land law? Well, as the name suggests, it involves the process of two or more people having title to a particular piece of land, i.e., they are multiple owners and they are co-owning that property. Now, there is an entitlement for the co-owners to own and jointly enjoy that land at the same time. And so there are various different legal principles therein that relate to this relationship, that seeks to regulate this relationship. And these are known as the types of co-ownership. So there are two main types of co-ownership that exists in land law. We can understand co-ownership as falling broadly into two distinct categories. You have firstly the idea of the joint tenancy. This is going to be the topic of the first lesson that when we get to looking at this in more detail. You then also have this idea of the tenancy in common. These two are both the types of co-ownership that you can actually have when we think about co-ownership of land. So what are the differences between the joint tenancy on the one hand and the tenancy in common on the other? Well, the joint tenancy refers to a situation where the occupiers of a property, i.e. the co-owners of a property, act as a single entity in relation to that property. They are one single unit to which the tenancy applies. So it's almost like you have a tenancy, okay? You have a tenancy, you have an ownership of a property, and this ownership of the property is one single ownership, but it is at least divided among the occupiers of that property. But they all equally own that property as a joint tenancy. They are all singularly, collectively, almost this merged together as a single legal entity, them being a joint tenancy. There is no separate shares in the property. There is no separate parts of the property that some people own that other people do not. Each of the owners, each of the occupiers of that property will entirely own the property equally. There will be a full 100% ownership among every single person. So sometimes you have co-ownership situations where there are actual physical divisions between different parts of the property, or the division of the property is based on shares of the property, which is often in relation to the asking price that is put forward, the amount of money that each of the individual tenants actually contribute to the asking price. That is not the case when we talk about the joint tenancy. That is the case, however, when we talk about the tenancy in common. This is where the occupiers of the property, while still co-owning the property, they will co-own individual shares of the property. You can clearly delineate, or at least there is the potentiality of clearly delineating these shares. There will be an ownership of the property despite there actually not necessarily being a dividing of the property at this point. Where there is a tenancy in common, the owners of the shares will often have a share division which reflects that of the initial price contributed. Now, what I mean by they have individual shares while not actually being divisible within the property is when we get to this idea of severance. Severance basically being where one person within the co-ownership decides to sever their relationship at least to the legal title of that property. Now, this can only happen with a tenancy in common. It cannot happen when it comes to joint tenancies, because with a tenancy in common, you can take the co-owners and they are divisible units. They are individual people. Whereas the tenancy in common, it's individual people, but they are represented in law as the same, as sort of a collective group that have ownership over said property. So that's what we're going to cover in the next lesson and the lesson after. We'll cover the distinction a little bit more detail between the idea of the joint tenancy on the one hand and the tenancy in common on the other, before we start talking about some of the more interesting elements relating to conversions from joint tenancies to tenancies in common, the relationship between law and equity in this particular area, and then talking about the idea of severance as well as the methods of severance.